everybody. Hopefully you didn't hear that brief technical glitch there. Let's just pretend that never happened. Welcome once again to Heinz Webinars, the regular deep dive into the weird and wonderful world of Strata and management rights in Queensland. There's a lot of it going on. My name is Chris Irons. I'm director of Stratasolve. That's stratasolve.com.au. Alongside me, as per always, is Frank Higginson, partner at Heinz Legal, which is the premier provider of legal services to the Strata sector in Queensland. Frank, hello.
Hello, Chris. Hello, everyone. Again, for what will be an interesting one.
A very interesting one. What's happening, Frank? Much?
Mate, reading new legislation, it's everywhere. So this is just one example of it, but there's, I suppose, consultation drafts lurking around in all sorts of places. So trying to actually get your head around all of that and the potential unintended consequences and what changes in practice is going to be remains interesting and challenging at the same time.
I'm hearing what you're saying there, Frank. Just before I came on air, I was reading up on motions ruling motions out of order for a client, and was actually reading it, trying to take a motion and find out a way it could be ruled out of order. It actually looked really watertight, all good, but I'm just sitting there trying to pick it apart word by word, so that I can find out, is there actually a way it could be done? So I hear what you're saying on that one. Interesting. But bit of housekeeping quickly for people listening in live on YouTube. You can post your questions in the chat. We'll try and get to as many of those as possible. For those listening in later via the podcast way of consuming this, so while you're out walking the dog or washing the dishes, you can find all the notes and links at heinzlegal.com.au. Frank, this week, or this time around, we're going to be looking at the changes to residential tenancies laws kicking off in Queensland from the 1st of October. I think you and I reckon, Frank, this is going to be a multi-part effort.
Yes, there's a heap in this. And it's really, and there's probably the stats there if we want to spend some time Googling, but, we've got 500,000 plus strata lots in Queensland. I don't know if we actually know the mix of what's owner occupied and what's short-term rented and what's permanently rented, but I think it's safe to say there's a couple of 100,000 tenants to which these laws are going to apply. And I think the process, and it's interesting, isn't it? Because this conversation started in 2019, probably early, maybe late 18, 19. We saw some inflation, and then suddenly COVID arrived and completely kicked into touch, and then sort of got re-geared with things settled down a little bit. So there was a little bit about then, but residential tenancy laws, in theory, you wouldn't think would apply to strata much, in the sense of, well, that's for people renting units, but there's definitely some big crossovers.
There's some huge crossovers, Frank. And we're going to go into briefly in a tick why that is the case, because I know that there can be a misconception out there that strata and residential tenancies just are two separate things. Yes, they are, but as you say, Frank, there's a really strong connection between them. So today, this is part one, if you like, and we're looking at the reforms that are commencing from the 1st of October 2022. There's a bunch of other stuff happening in residential tenancy law reform, but today it's just on this component. All right, well, look, let's sort of clarify why anybody should care in strata world, what happens with residential tenancies. Frank, what is a tenant called under strata legislation?
An occupier. So there is that's it. Occupier is it's the word that the legislation uses, and that takes away this tenant, permanent, guest, customer, short-term accommodation provider. It's someone occupying a unit. There's no reference at all to the tenure of their occupancy. So every tenant is an occupier of whatever nature.
That's right. So that means also commercial tenants as well. They are occupiers. And so, so we've established that, but what's the big deal? I mean, occupiers don't have rights to vote, do they?
Not yet, as much as that was one of the discussion papers that we had there for a while. They've certainly got obligations in relation to the bylaws. And one of the things I think that, you can see coming from a legislative perspective, and particularly as the industry starts to look towards stuff build to rent. It's sort of the maybe, and I don't know, the great Australian dream of home ownership has evaporated for a few people. So if we're becoming, like it is in Europe, I suppose, where you just rent and that's the way of life, and you don't even think about owning your own property, then subject to which side of politics you might come from, and I think probably it's fair to say the Labor side of things is probably more pro-tenant than the LNP side of things. You might start to see more tenants' rights or occupiers' rights appear because, and I suppose if you do step back and look at it from a macro perspective, people living in a building together, regardless of the nature of their style of occupancy, being owners or tenants, do have a lot in common. And so it's a question about how you sort of manage and balance those interests effectively, recognising some people have spent substantial money to get in there, but also recognising that other people live there full time. And that's sort of where we're going today with this stuff.
I think that those are really good points, Frank. And when you look at the political landscape and how the Greens in particular are pretty much in control of inner city Brisbane, and will likely be in control of inner city Brisbane for some time to come, they have an incredibly strong pro-tenant agenda. They're very open about that. And I think more and more, you're quite right, Frank, we will see government policy and legislative reform tipping in favour of the tenant, which is all well and good up to a point, and then we reach the situation that we're going to talk about today, which is where it does not become all well and good. So let's clarify what we're talking about. So look, the Residential Tenancies and Rooming Accommodation Act is the act that we're talking about. That's been under review for a long time, very similar to the BCCM Act review. It's been going for years and years and years. It's been happening in a series of phases. Phase one is already in place, actually. That's been in place since October 2021, I think, Frank, largely relating to domestic and family violence provisions, and largely a replication of what happened during the worst of COVID, which is when a range of emergency provisions were put into place around residential tenancy. So those reforms are already in place and operating out in the marketplace, I guess. Okay. And very quickly, it might be worth just touching upon the relevance there to Strata. So one of the big reforms that's in place relating to domestic and family violence enables an occupier to replace a lock pretty much immediately and pretty much unfettered, I think it's fair to say, Frank. Yeah. Why is that a drama for Strata?
Because locks are quite often common property. So it's that, and here's this, what we're talking about today, it's this interface of tenants' rights with respect to what would normally be common property and body corporate issues, where effectively legislation now says tenants can do things to properties in certain circumstances and in particular personal circumstances that they've got that would ordinarily require committee, general meeting, body corporate approval in some way, shape or form. So, and that, it's very hard to sit here and say it's not appropriate for people to be able to make themselves feel more secure if they're threatened by or in genuine fear of domestic violence and that sort of stuff. So, and that, to be fair, has skated through. It's been there for ages. I can't recall a single instance of having to advise on it or even a query about it. So,
same, Frank. Yeah,
that's probably fair, fine. And if it is popping its head up, everyone's accepting the reality of it, which is a good thing.
I think so too, yeah. The issue about locks and front doors generally remains, though, in Strata. It's often not clear what a lock and a front door is in relation to individual or common property. That is one thing which remains regardless of all of this. So, yeah, sorry, Frank, you were going to say?
I was going to say, particularly in building format lots as opposed to standard format lots. So townhouse estate's probably okay, but if you're in a high rise,
Absolutely. So what's next then? Well, these are the reforms kicking in from the 1st of October, and we're going to put up a link there that the Residential Tenancies Authority, which is the font of knowledge when it comes to this sort of thing. And we should have clarified at the start, Frank, you and I, we're Strata experts, I think. I'd like to think that we are. We are strata experts insofar as strata and residential tenancies law intersect. When it comes to residential tenancies legislation generally, I'm not going to call myself an expert on that. No, a little bit.
Yeah,
but
a
I'm
little
not
bit
an
about
expert.
a lot, but yeah, not a lot about that.
All right. So the big thing that's happening from the 1st of October, there's a few things, but the big thing will be our favourite pets, everyone's favourite when it comes to strata. So let's just clarify one thing which isn't changing whatsoever, and that's going to be 2 sets of approvals, one from the landlord and then one from the body corporate. Always with the proviso, Frank, and this often gets overlooked, that if there is no bylaw about pet approval or needing approval, then there's nothing stopping a pet being kept from the body corporate perspective.
Correct. And I think probably the big change here is that up until the 1st of October, landlords can say no pets. And that's just their prerogative. It's their property. They can say yes on whatever basis they want. That's changing. So now it's landlords can only refuse pets if there is an exceptionally good reason to actually do so. And when you look at the provisions in the legislation, they're not identical, but they're very similar to where I suppose decided cases have come from a Body Corporate and Community Management Act perspective.
They are, Frank, and I can confirm that when these new laws were first being drafted and developed way back when, I was still commissioner at the time, and I was consulted by the Department of Housing about them, and they very sort of clearly asked for examples of adjudicators' orders and typical statements, typical conditions, typical discussions about reasonableness as it related to keeping a pet and pet approval. And you're quite right. The legislation, the new legislation coming into effect from 1st of October reflects that. And so I think in particular, we'll just read this one out. This is what part of the new laws say: to remove any doubt, it is declared that a lessor's refusal of a tenant's request on the grounds that no pets are allowed is not enough to comply with subsection blah, blah, blah. That actually goes a step further than body corporate.
It's far more prescriptive. And it's when I was reading the legislation, it's sort of, they built in some conditions that are there now by law, you know, in terms of if a pet's inside, then it's reasonable for the carpets to be professionally clean at the expiration of a tenancy. If a pet is an outside pet, it can't come into the premises. So they've actually built into the legislation some of the conditions that you see all the time. But that specific one there, we're saying no pets. They black and white said that's not good enough. There's got to be some other really, really good reasons. So, and the difficulty with this, I suppose, is that in 18 months, 2 years' time, we'll see decided cases where those provisions have been tested and discussed by members in QCAT.
Yes.
Because this isn't a body corporate dispute. This is a landlord-tenant issue. So you've got 2 jurisdictions there. So it's really, it's a can of worms. And I think there's a lot of confusion.
It's huge. And probably one of the biggest issues that arises therefore is that under the new laws from the 1st of October, the landlord has 2 weeks to consider the tenant's request for a pet. And if within that 2 weeks there's no decision, then it defaults to approval. That's the residential tenancy side of things. From a body corporate side of things, a body corporate has 6 weeks to consider a request to keep a pet, and then they can take another 6 weeks on top of that in some cases. So you can have a situation where you might have a tenant occupier about to move into a community title scheme as a tenant, seeking a pet approval, and we haven't even touched upon the state of the rental market in this discussion, and we probably won't go there, but in a really hot rental market, this is all going to be intensified even more. So you have tenant moving in, pet approval, applies to landlord. Landlord either says, well, I can't say no, so it's a yes, or refuses to say anything, at which point it's a yes anyway. after 2 weeks. And then the tenant goes, oh, hang on, what about the body corporate? That's assuming, Frank, of course, they're actually aware a body corporate exists at that point.
Yes. Yes, this is, I suppose, come back to that management rights model again. People who are renting through on-site managers, the on-site manager is going to know the rules, but if you're renting through an owner direct or some off-site agent that doesn't necessarily understand how bodies corporates work, and okay, well, the landlord's consented in, you go in with your pet, and the committee says, what the hell is that?
Yeah.
That's it's that, I suppose it's another layer of bureaucracy or issues or just understanding, and it's easy, and I sometimes we talk about this stuff all the time. We live and breathe it. So for us, it's like, well, bang, bang, there's your layers. You need to do that. Here's who you need to hit up. You got a landlord, then you write the body corporate manager. They'll have a pet application and blah, blah, blah. For the uninitiated in this space, it is going to be horribly confusing.
Oh, and so many tenants are vulnerable people, Frank, and they're just focused on finding somewhere to live. They're not focused on the nuances of body corporate legislation. So what does all that mean? Well, I think one of the things it's going to mean is that my former office, the Commissioner's office, is going to see a whole wave of interim order applications because, what do you think, Frank? Do you think that's a likelihood?
Yeah, and I reckon the inquiries to the phone service and the emails will go up, I wouldn't say exponentially, but there's going to be more of them because suddenly, and it's even, landlords ringing to try to understand the state of play because this RTA issue really isn't a BCCM issue, but that's where they're going to be going because they'll see body corporate pet refusal. And if you Google that, that's probably what you're going to find first up.
I think that's right. So just to clarify what we're talking about there, as an occupier under body corporate legislation, an occupier is entitled to lodge a dispute resolution application against the body corporate. Body corporate is too, for that matter, against the occupier. And they can seek an interim order application, which is a bit like an injunction, where keep the pet subject to final determination. I think you're quite right about the information side of things, Frank, that there'll be a lot of inquiries and confusion. And I think that confusion issue is probably, in the longer term, the bigger problem that's going to arise here. So you've got occupiers who are just running around madly, signing leases, getting utilities connected, organising movers, packing their place, all the rest of it. Then they've got FIDO, and they just assume, well, FIDO, it's fine to keep FIDO because the new laws make it easy for us to keep FIDO. But then they move into an apartment and find out, well, first of all, there's a whole other set of rules. There's this mysterious thing called the committee, and keeping a pet is actually not automatic. And of course, Frank, it's important to remember in some limited cases, but it exists nonetheless, the body corporate can indeed prohibit pets altogether.
Yep, absolutely. So it's going to be really interesting to see the interplay, and interesting in a bad way in some sense. And I don't know how you try to reconcile the timeframes and all that sort of stuff, but here we are. So again, it's just a matter of trying to be aware if possible. So what's the solution for this one is make applications as far in advance as possible, because if the body corporate's going to exercise its statutory rights to take 6 weeks to make a decision, then I don't think you're going to be able to make an interim order application until that's actually expired. Like smashing someone to say you've had a week now. It's like, well, hang on a minute. The committee of volunteers, there's a body corporate manager involved, there's costs involved, there's time. It's just that
the pressure on committees will be pretty intense, I would think, to make decisions quickly. And you can see that there would be some instances where approving a pet should be fairly routine under a permissive pet bylaw, but there will be other instances where it certainly won't be. And as you quite rightly point out, Frank, if the committee are spread far and wide, say interstate, overseas, or just not available because they've got life to live, you can't, the occupier, the landlord, or the real estate agent can't turn around and say, well, you must decide this within a couple of days. It's going to be particularly fraught, I think, Frank, in a situation where the market for tenants swings back in favour of the tenant as opposed to the landlord. So where you've got tenants having far more choice and actually negotiating prices down. When that happens, there'll be much greater demand on the part of landlords and agents to secure a tenant, which in turn will want approval for pets done far more quickly. That's probably where it's going to be felt the strongest.
So, and I suppose then good body corporate managers, and a lot of them will have this already,
Yep.
will sort of have the policies in place and the processes in place to be able to report to the committee and say, okay, an application for Chris, for Ernest, here's the resume, here's the approval, here's the conditions, can you please confirm that's okay? Bang, bang. Because it just, and I suppose, as always, it's all well and good to say you can take 6 weeks, but do you need to cause everyone the grief by doing it if it's laid out in the there?
Absolutely, and I haven't even introduced the idea of being asked to pay for urgent approvals either, Frank. We might get onto that another time.
Keep everyone guessing.
Yeah, the answer's no, by the way, everyone. So just to clarify what else is going on in this space, so the Commissioner's Office, Commissioner for Body Corporate and Community Management, they actually got some money in the budget to deal with this, which was a bit of a shock, and they're going to need it, I think. There's going to be an awful lot of content to be developed around this point to complement the existing content on pet approvals. I understand also that office will be delivering some info sessions in conjunction with the Residential Tenancies Authority leading up to the 1st of October. So make sure that you are signed up to the various offices to get that kind of information. Very quickly then, also, so it's mostly pets that we're talking about today, but there's 1 or 2 other things happening from the 1st of October as well. One of those that is relevant to Strata is that there's going to be some changes in the way in which a tenant goes about getting emergency repairs. Now, I think, Frank, the first thing to remember here is that one person's version of emergency is certainly not another's, is it?
It's a very subjective word, emergency. And I know from a Commissioner's Office perspective, that, practice directions about emergency spending and getting approval to spend money on an urgent basis, has repeatedly said emergency is not lack of organisation on your part that is now constituting an emergency on mine.
Yep.
So ignoring stuff and letting it drift for months and weeks and whatever it might be, and then suddenly deciding, no, I need to fix it, is not an emergency at BCCM land. And you think it's going to be relatively similar to this.
Yeah, it's something which fails without any warning, I suspect, is probably a good rule of thumb on this. And so what's the big deal? Well, there's going to be a few changes about how the tenant facilitates emergency repairs, because the general rule of thumb, of course, Frank, is that if I'm a tenant and a maintenance is required, I report it to my property agent or the landlord, as the case may be, and then there's a process of having the work approved by the landlord, and then a contractor is engaged, they come out, you wait between 9 and 5 on a given day for them to turn up, and away you go. But if it's an emergency, a genuine emergency, then that process doesn't necessarily apply that way. The tenant has some ability to get it fixed there and then.
And this is, I suppose, another pro-tenant move, and probably you'd probably look at it and say there's absolutely going to be some landlords that will not take their obligations to provide quiet enjoyment, vacant possession, all that sort of stuff. So tenants can apply to QCAT for orders to allow them to do these things on an urgent basis. And that's what will happen. So again, if you're a landlord and you're ignoring things, potentially risk it. If you're a body corporate and ignoring things, this is where the issue comes up, isn't it?
That's right. And the big deal there, of course, is that it might be a situation where the emergency repair impinges upon common property. In fact, you can see many instances where that would be the case. A good example, I would think, Frank, is a storm, like a major.
Water.
Yep. Water ingress dripping through the fixtures in the ceiling, electrical shorting out. Now, that's an emergency on the part of the tenant. I don't think anyone would argue otherwise on that. But where did it come from? Is it through a failure of common property? If it is, then that's a body corporate responsibility, isn't it?
Yep. And body corporates have statutory obligations to keep common property in good repair and condition, and sometimes they don't do that. Sometimes they're not aware of it. But either way, what these provisions are basically saying, fix it and argue about where the responsibility might lie later. as opposed to figure out where the responsibility is and go through all the reports and all that sort of stuff, and have someone with water leaking through their roof for 3 months before they figure out what's going on.
So in effect, we think that these provisions might affect the ability of the body corporate to maintain common property in the way in which they should be, because somebody else will be doing it in that case. So I suppose what we're trying to say is that maintenance of common property might be able to happen without any involvement of the body corporate, which is an interesting development.
Yeah, and then you start to deal with who's responsible for that maintenance, because normally, if an owner-occupier does something, then they're responsible for it. But is that going to be the case here? So there's all these sort of things that flow out, and inevitably there's consultation, I suppose, that's happened internally, Chris, but whether it's all been listened to and taken clearly into account, or we're just going to get it out there and let's go.
Yeah. And then there's the practical aspect of it. There are so many nuances that legislation can't immediately fix, of course. So I think, Frank, you and I both think that those particular provisions about emergency repairs probably need just a bit more exploration and see how they pan out over time, see how they affect Strata. So look, we're approaching the end, so quick sort of reflection. What does all this mean for Strata? What's the best practice? Well, I think the fundamental is if you're a committee, manager, caretaker, you can't ignore an occupier. You certainly can't ignore the occupier's rights, nor should the occupier ignore their responsibilities, of course. Remember also, we talk about misconception a lot in this discussion. There's this misconception that if there is an issue involving an occupier in a strata scheme, that the engagement has to be direct with the landlord or direct with the property agent. And it's not the case. Body corporate should be engaging direct with the occupier, particularly when it comes to bylaws, and the other way around too. Occupier direct with body corporate. By all means, involve the lot owner and the property agent. That's the ideal, I think, Frank. No one would deny that. Involve them, but when it comes to taking action, it doesn't rely upon them, I don't think.
No, there's a direct line there. The legislation specifically refers to the rights of occupiers, which is tenants. So, there's none of this having to go through third parties. You can go direct.
I think the other thing, a good takeaway leading up to the 1st of October, and time is rapidly running out on that, but for committees, this is a really good opportunity to look at their decision-making processes, their communication processes, how they meet or how they decide upon things, and probably also their pet bylaws if they haven't already done so. Now is the time. Oh, it's actually too late for the 1st of October, but you might as well start somewhere. As we said at the start, we think this is probably a multi-part discussion because there are other residential tenancies reforms coming up. One of the big ones, and we're going to talk about this in a future webinar, is a little old thing called minimum housing standards. Sounds innocuous, Frank?
Oh, it's always. It's the devil is in the detail, and there's some detail behind that one. And that leaves aside what the actual, notices to leave people might have been seeing in the media as well. So there's a lot in this legislation. So give us something to talk about and get our heads around, which is great.
So stay tuned for the next instalment of this discussion. But for now, we've reached the end. That's all we have time for. You can find all the notes and links. So we'll have a link to the actual amendments at heinzlegal.com.au or on YouTube. That's Heinz Legal YouTube channel. You can find me at stratasolve.com.au, and you can find Frank at heinzlegal.com.au. But until next time, Frank, farewell.
Farewell, Chris. Thank you, everyone.
Thanks, everyone. See you later.